By the summer of 1932, the Dow Jones Industrial Average had fallen more than 89% from its September 1929 peak, a decline documented in historical market data widely cited by financial historians, including Yale economist Robert Shiller. Thousands of banks had failed. Unemployment stood near 25%. The public wanted to know how it had happened and who was responsible. The Senate Banking and Currency Committee opened hearings in April 1932, tasked with investigating stock exchange practices and the conduct of large financial institutions. The first 8 months of those hearings, under a succession of counsels who lacked either documents or tenacity, produced little of public consequence. Ferdinand Pecora was born in Nicosia, Sicily, in 1882 and came to the United States as a child. He worked his way through law school and eventually rose to assistant district attorney in Manhattan, where he prosecuted bucket shop operators, small-time securities fraudsters who took customer orders and simply pocketed the money rather than executing trades. When the Senate Banking Committee's chairman, Peter Norbeck of South Dakota, hired Pecora as chief counsel in January 1933, the intent was to wrap up the investigation with a final burst of hearings. Pecora had other ideas. He requisitioned the internal records of the largest banks in the country, read them methodically, and built his questions from the documents outward. National City Bank, the institution that would eventually become Citibank, had a securities affiliate called the National City Company. In the late 1920s, that affiliate sold hundreds of millions of dollars in Latin American government bonds to retail investors across the country, in some cases through aggressive sales campaigns. Pecora's documents showed that the bank's own analysts had written internal memoranda warning that Peru's finances were precarious and that its debt carried serious risk. The bonds were sold anyway. As historian Michael Perino documented in his 2010 account of the hearings, The Hellhound of Wall Street, National City salespeople were in some cases compensated based on volume sold rather than on the quality of what they sold. When Latin American defaults arrived after 1929, retail buyers were left holding nearly worthless paper. Charles Mitchell was chairman of National City Bank and one of the most celebrated financiers of the 1920s. Pecora called him to testify in February 1933. Under questioning, Mitchell acknowledged that in late 1929, when the bank's stock price was falling and creating paper losses for his personal holdings, he had sold shares to a family member at a loss, used that recorded loss to eliminate his federal income tax liability for the year, and then repurchased the shares shortly afterward. The transaction was legal under the tax law of the time, but the spectacle of the country's most prominent banker paying no income taxes in a year when millions of Americans were losing their savings was devastating. Senator Carter Glass of Virginia, no populist, reportedly called Mitchell the most dangerous man in America. Mitchell resigned from National City Bank shortly after the hearings. If the National City revelations damaged one bank, the Morgan hearings damaged the mythology of American finance itself. J.P. Morgan and Company had distributed shares in new stock offerings to a list of favored individuals at prices below what the public would later pay, allowing those individuals to profit the moment the stock began trading on the open market. Pecora obtained the list. It included former President Calvin Coolidge, Democratic Party elder Newton Baker, financier Bernard Baruch, former Treasury Secretary William Gibbs McAdoo, and roughly 60 other prominent Americans spanning both political parties. The partners of J.P. Morgan and Company, Pecora also revealed, had paid no income taxes in 1931 or 1932, legally, because Depression losses had wiped out their taxable income. The revelation that the most powerful private bank in the country had quietly given pre-market stock to sitting politicians and former presidents consumed the country's newspapers for days. The hearings drew enormous press attention and became something of a public spectacle. On May 23, 1933, a publicist working for Ringling Bros. Circus placed Leah Graff, a diminutive circus performer, on the lap of J.P. Morgan Jr. during a hearing recess, creating a photograph that ran in newspapers across the country. Morgan's expression of bewilderment became one of the defining images of the era, a symbol of how thoroughly the great bankers had lost their standing in public estimation. Pecora understood that publicity mattered. His methodical release of documents, timed to maximize embarrassment of each witness during peak press coverage, built the political pressure that gave legislators the opening they needed to act. Scholars who have studied the Pecora record are careful to note that much of what was revealed was legal under the rules of the time. The deeper finding was structural. The same institution could simultaneously lend money to a company, underwrite that company's bonds, sell those bonds to retail customers through an affiliate, and collect fees at every step, without disclosing any of these conflicts to the buyer. As legal historian Joel Seligman argued in his History of the SEC, The Transformation of Wall Street, the hearings demonstrated that self-regulation had failed and that mandatory public disclosure was the only mechanism that could protect investors who lacked the information to protect themselves. The first legislative response came quickly. The Securities Act of 1933, signed by President Franklin Roosevelt on May 27, 1933, established that anyone offering securities for public sale must register those securities with the federal government and provide a prospectus containing material information about the issuer's finances and risks. The principle was simple. The government would not tell investors what to buy, but it would require sellers to tell investors what they were getting. Fraud or material omission in a prospectus became a federal offense. Historians credit James Landis and Benjamin Cohen, associates of Harvard law professor Felix Frankfurter, as primary drafters, working from British disclosure law as one model. 3 weeks after the Securities Act, Congress passed the Banking Act of 1933, signed June 16, 1933, which contained the provisions known as Glass-Steagall. The law required commercial banks, which held customer deposits and made loans, to separate from investment banks, which underwrote and sold securities. A bank could not do both. The logic was that the conflicts Pecora had documented at National City and its securities affiliate could not be regulated away through disclosure alone. The activities needed to be structurally separated. The same law created the Federal Deposit Insurance Corporation, insuring deposits up to $2,500 per account under its initial temporary provisions in order to stop future bank runs before they started. A year later, the Securities Exchange Act of 1934, signed June 6, 1934, addressed the secondary market, where stocks and bonds traded after their initial sale. The act required stock exchanges to register with the federal government, mandated periodic financial reporting by publicly listed companies, banned certain manipulative trading practices such as pools and wash sales, and created a new independent agency, the Securities and Exchange Commission, to enforce the rules. Roosevelt's choice for first SEC chairman was deliberately unconventional. Joseph P. Kennedy, a man widely believed to have profited from some of the speculative practices the SEC was created to stop. Roosevelt's reasoning, as accounts of the period suggest, was that experience on both sides of the market was an asset for a regulator. Ferdinand Pecora was appointed as one of the 5 original SEC commissioners and later served as a New York State Supreme Court judge. His name faded from broad public memory, though legal historians kept it alive. The architecture he helped force into existence did not fade. Every IPO prospectus, every quarterly earnings filing, every broker conflict of interest disclosure, every rule against insider trading traces in some form to the statutes passed between 1933 and 1934. When Congress debated repealing Glass-Steagall in the 1990s, some historians and legislators invoked the Pecora record as a warning. The repeal came anyway in 1999 under the Gramm-Leach-Bliley Act, and the structural separation that Pecora's hearings had helped justify was removed. When you open a brokerage account, the firm is legally required to disclose conflicts of interest it may have in recommending investments to you. When a company goes public, it must file a prospectus disclosing its finances and risks. When corporate insiders buy or sell shares in their own company, they must report those transactions to the SEC. When a bank holds your deposits, those deposits are insured by the FDIC up to current limits. None of these protections existed before 1933. They came from a single sustained investigation conducted in borrowed hearing rooms during the worst economic crisis in the country's history, driven largely by one lawyer with subpoenas and a talent for reading documents. Whether these protections are sufficient is a question regulators and legislators revisit constantly, but knowing where they came from clarifies what they were designed to do and what falls outside their reach.